years a real momentum around the question about whether or not we should stick with 9. I think we started with 5 justices. At the founding, we then had 6. For a while, we had 10, but starting in, I think, 1867, we left it at 9, and that's where it's been for roughly 150 years. That's just something set by statute, and it can be changed by statute. Now, historically, I think that justices have tended to think a lot about their abilities. This is what Justice Chase's best friend said about him. Quote, "Chase is a good man, but his theology is unsound. He thinks there's a 4th person in the Trinity." And some justices are known to be, a little bit insecure about their power. Chief Justice Berger in the 1970s, he put a cushion on his chair so that he would appear taller than the other justices at oral argument. And others are just profoundly human and have incredible wry senses of humor and are self-deprecating, but also genuinely so. And 2 examples of that. One is former Chief Justice Rehnquist, whom I had the privilege of clerking for Justice Breyer, but you get to watch the other justices in action. And the Chief Justice he was humble. He was incredibly smart and efficient. He really only came in like 4 hours a day and got everything done. Well, when you're a justice, there's really only one occasion you ever give a press conference. And that is when you are elevated from being associate justice to being chief justice. And so that happened back in 1986. And the chief justice is giving his press conference. And the first question is, "What did Mrs. Rehnquist have to say when you called and told her the news?" And he said, "Well, she said, unload the dishwasher." That's what he was like. And the other person whom, when I was clerking, this was very palpable about was Justice Suter, David Suter from New Hampshire. Now, Justice Suter really did not like Washington, D.C. And the Supreme Court operates like school and school children that ends at the end of June and restarts in basically the end of September. So they get like a long summer break. And Justice Suter took that break really seriously. Like literally the minute that court ended on June 30th or so, he'd pack his car up with his books. He loved the classics, Proust and Shakespeare and the like, and he'd drive up to New Hampshire. And he'd spend 3 months in his cabin there reading, and then come back to DC. Not, I think, all that happy about coming back to DC, but would. Now, one day he's driving up to his cabin in New Hampshire, and he stops at a rest stop in Massachusetts. And this man, a couple, a man and a woman, and they look at him, and the man says, I know you. And the justice, who's really, really polite, says, "Sir, I don't believe we have met before." And the man says, yeah, you're that fellow on the Supreme Court. And the justice says, "Yes, that's right." And the man says, yeah, you're that fellow Breyer, Stephen Breyer. And the justice, who's so polite, doesn't want to, embarrass the guy in front of his spouse and so on. He just changes the subject. They talk about stuff for a few minutes. And then the justice says, "I'm sorry, but I really have to get back on the road and make it to my cabin by nightfall." And they part ways and they start walking away. And then the man says, "Wait a minute, before you go, one question. What's the best thing about being on the Supreme Court?" And the justice responds without missing a beat, "I'd have to say the best thing about being on the Supreme Court is the privilege of serving with David H. Suter." So the court can be, rather interesting and a little bit unpredictable. I know that there's a lot of talk, and some of it's right, about the polarized nature on the court and the like. But a lot of times the justices can really surprise you. My favorite case that explains that is a case called FCC versus AT&T, Federal Communications Commission versus AT&T. And the question in the case was whether the Freedom of Information Act, which protects records, has an exception for personal privacy Well, it does have that exception, personal privacy. The question is, do corporations like AT&T count? Can they raise a personal privacy exception? Now, this case was coming up when I was running the Solicitor General's office in, I think, 2011 or so. And the year before, we had the case of Citizens United. And I was the deputy on that case. And that was a case involving whether or not the corporations have free speech rights under the First Amendment and whether campaign finance restrictions could be permitted. And I think all of you know that case a bit. You've heard of it. President Obama, in the State of the Union address, attacked the Supreme Court while they were sitting right there, saying 5-4 that corporations have free speech rights. And so the next year is coming up this question, okay, they have free speech rights. Now, do they have privacy rights? And so everyone's like, this is Citizens United Part 2. It's going to be, another 5-4 bloodbath and the like. And so the newspaper headlines are all like Citizens United 2.0 and the like on the day of the argument. So the lawyer for AT&T stands up at the podium and he says, the Dictionary Act, which is the first statute in the United States Code, defines persons as including artificial persons, corporations. So he says, persons are corporations. There's an exception for personal privacy in the Freedom of Information Act. AT&T is a corporation, ergo, AT&T has a personal privacy exception. And the Chief Justice, now it's Chief Justice Roberts, who actually clerked for Chief Justice Rehnquists back in 1980, but Chief Justice Roberts stops the lawyer for AT&T right away and says, well, wait a minute. The exception in the statute is personal privacy. And you're giving me a definition of person in the Dictionary Act as including an artificial person. But isn't there a difference between person and personal? And the lawyer for AT&T said, I don't think so. I don't know what you really mean. And the chief said, well, words have different meanings from their roots. And the lawyer for AT&T said, I don't think so. Well, the chief said, what about pastor, pastoral? What about craft, crafty? What about squirrel, squirrely? And the poor lawyer for AT&T doesn't have any answer to this. Leading the Supreme Court in a unanimous opinion just a few weeks later, written by the Chief Justice to rule against AT&T, 9-0. And the Chief Justice concluded his written opinion with the words, quote, we trust that AT&T will not take it personally. So that was a case about 10 years ago. Obviously, we have 3 new justices on the court just in the last few years, all appointed by President Trump, all replacing justices that were conservative themselves, but not nearly as conservative. Well, excuse me, 2 of them. Justice Ginsburg is replaced by Amy Coney Barrett. So, you do have, at least with 2 of the jurists, I think, a move toward a much more conservative jurisprudential approach. Justice Gorsuch replaced Justice Scalia. That was probably not a move toward a more conservative jurist. Indeed, Justice Gorsuch has written opinions protecting LGBT workers and Native Americans and the like. It's unclear that Justice Scalia would have written or signed those opinions. But certainly Justice Kavanaugh for Justice Kennedy and Justice Barrett for Justice Ginsburg have moved the court to the right. That has obviously been a programmatic agenda of the Republican Party for a long period of time. And it is now at this point looking successful. The question is how successful it will be. Well, let me give you a little data about the 1 year we have with the court with Justice Barrett on it. So they heard 58 cases last year, and they wrote 67 opinions. There were some kind of summary reversals and the like, which meant that they decided a few more cases. But that's a really low number to decide 67 cases. The year before was even lower. It was 53 cases that they decided. Back in the 1980s, they used to decide about 150 cases. I think 53 is as low as anything since before the Civil War. Obviously, it was COVID related. And I'll talk a little bit later about how COVID has changed some things at the court. But basically, they're hearing very, very few cases. Now, when they hear a case, they affirmed last year 1/3 of the time, 33% of the time, and they reversed 67% of the time. And if you look over the last 10 years, it's a reversal rate of about 3/4 of the time, 75%. What does that mean? That means, like, if you won your case in the Court of Appeals and the Supreme Court agrees to hear your case, that's really bad news for you. That means 3 out of every 4 times you're going to lose in the Supreme Court. The Supreme Court gets asked to hear about 10,000 cases a year. That's what's called a petition for certiorari. That's like saying to the Supreme Court, hear my case. I've got a good argument. And the Supreme Court, as I say, hears about 60, last year, 58 cases, whatever, a very small number of cases. So it's like the odds are really very hard to get your case heard by the Supreme Court. And if it is heard and you won in the Court of Appeals, then that's bad news for you in the Supreme Court. Now, I know that, as I say, there's this image of the Supreme Court as being incredibly divided, but I would say it's important also to think about the fact that the court acts unanimously a lot of the time. Last year, 43% of cases were decided unanimously. The average over the last decade is 47% of cases decided unanimously. 3 years ago, we had a situation in which 67% of the cases were decided unanimously. You'd have to go back to the Civil War to find a comparable high rate of unanimity. This is something the Chief Justice talked about as confirmation hearing. It's something Justice Breyer's talked about, the idea that the court should try and speak with one voice where it can. Obviously, it doesn't always pan out, but it is something that I think you see different justices on the Supreme Court caring a lot about. In terms of who's voting with whom, this is always kind of interesting. So last year, Justice Kavanaugh and Justice Roberts, the Chief Justice, agreed the most. They agreed 94% of the time. The next highest group of pairings was Justices Sotomayor and Breyer and Justices Kagan and Breyer, both of whom agreed 93% of the time. And Justices Kagan and Sotomayor reached only an 88% agreement level, so something slightly lower than that. Justice Kavanaugh was in the majority in the most number of cases last year, 95% of cases. There's only one other jurist in the last decade that has reached a 95% mark in divided cases, and that was the Chief Justice the year before. So Justice Kavanaugh really kind of, in some ways you could say, acting much more as the swing vote on the court at this point in time. There's also different strategies of being a jurist at the court. And, I'm almost done with the data, and then I'll dive into a few of the cases. But I think one real question justices face is, do they have a more kind of go it alone approach where they're going to write a lot of opinions, separate opinions, usually just for themselves, which are called concurrences or dissents? Or are they going to just speak rarely and only when they have something really important to say? Well, Justice Kagan and the Chief Justice are both always at one end of the spectrum. They write very little. Like last year, they wrote 11 opinions each. And Justice Barrett, who had just joined the court, also appeared to be following that strategy last year. She only wrote 8 opinions. But then if you go on to the other side of the court, Justice Thomas writes the most by far every year. Last year, he wrote 23 opinions. Justice Sotomayor is also in that camp, last year writing 22 different opinions. So there are different ways to do the job. I think that's what makes one of the things so interesting about the court is you got 9 of them with, in some ways, 9 different approaches, not just to the law, but to the way of doing the job. And unlike any other part of human existence that I'm aware of, when a justice joins the court, like when Amy Coney Barrett joined the court, she walks into that conference room, looks around at those other 8. Those are her colleagues for the rest of her life. And, that changes things immensely when you're such a long-term, to use the game theorist, long-term repeat player. It changes the way I think you do the job. They know each other incredibly well. I mean, better maybe in some ways than their spouses know them. They're thrown into a professional environment for a long time. And what that means is there are certain norms that develop. Like there's a norm against log rolling. It's not like you could go, Justice A can go to Justice B, hey, I really care about this case. If you vote my way in this case, in some other case, I'll vote for you. That kind of stuff happens in Congress. Does not happen at the court, would never happen at the court. It would be a serious breach of norms. The idea is everyone should be, really trying to articulate their view of what each case is about on the up and up. Okay, so we're going to talk today about the role of the Supreme Court in times of armed conflict. And what I thought I would do is just tell you a couple of stories about cases that I have and give you some of the background, and then I'd open it up to questions. So the first thing I want to talk about is my very first case at the Supreme Court, which was Guantanamo. And I was a law professor at Georgetown. And, I've been thinking about it a lot because of the 20-year anniversary of 9/11. And I was horrified that day. My first son had just been born 2 weeks before, and I'd previously served as national security advisor at the Justice Department in the Clinton administration, where one of my jobs was to think about the legal response to the embassy bombings and the military response and whether it was lawful to the embassy bombings in Africa. And I was definitely known as a hawk on Al-Qaeda. The 9/11 Commission, had said, even read some of my stuff and said how much of a hawk I was. But I remember being just so devastated that day, as we all were. But for me, just to think, God, could we have done stuff differently when we were in government and the like? And I was searching around for things to do. I started working with some first responders and the like, but I didn't really know what to do, but I felt like I should do something. And then on, November 13th, 2001, I'm watching the news, as I used to do a lot after 9/11. And how the news stations all moved to that crawler thing at the bottom, that ticker. And it said, President Bush issues military trial order for suspected terrorists at Guantanamo Bay. And I thought to myself, I don't know how they could be doing that, because we looked at that in the embassy bombings and thought, could we have military trials for these folks? And we said it was obviously unconstitutional. So I'm like, I wonder how they're doing that. And so I got on the internet, and I was teaching at Yale at the time and living in another professor's house who was away. And, she had a dial-up internet connection. So I'm like typing in, whitehouse.gov on my dial-up internet connection. And I see this order by the president. And my first reaction was that I thought it was like a joke. I thought it was on like a spoof White House website, because it just seemed to me so obviously unconstitutional. The president was saying that he could set up this trial system from scratch on his own with the stroke of his pen, and that he could handpick the defendants who would face this trial, handpick the prosecutors, handpick the defense attorneys, write all of the rules for the trial, including defining what offenses are, what the elements of the offenses were, what rights the defendant has. He later said 0 constitutional rights at Guantanamo, 0. He was going to pick the punishments, which included the death penalty. He was going to handpick the judges, handpick the appeals judges. And the very last lines of the president's military order said that the federal courts have no business reviewing what he's doing, no writ of habeas corpus at Guantanamo Bay. Now, I was as I say, a huge hawk on national security issues, big believer in presidential power, but I thought that went too far. And I came into my constitutional law class printed out copies of the order and explained why. And up until that point, I think they were all giving me a hard time throughout the semester because they're like, you think if the president does something, it's automatically constitutional and the like. And that, of course, wasn't my view, but it was an easy thing to caricature. And so I came in and said, look, here's something I think is really obviously unconstitutional. And there was a woman in the class who used to work for Senator Leahy, who was at that point the chairman of the Judiciary Committee, and she told him about my views, and he decided to have a hearing, and he invited me to testify. This is 15 days later, November 28th, 2001. So I travel from New Haven to DC, and I testify, and I say, look, I don't know if we need to have military trials or not. The one thing I'm sure of is the president can't do it by himself. Congress has to authorize this. That's our separation of powers. Congress makes the law, the president enforces them. The president can't make the law, Congress can. And the administration sent up as their witness Michael Chertoff, who was at that point a high-ranking Justice Department official, and his argument was, look, we don't have time. Suppose we capture bin Laden tomorrow. We need to try him, and so we don't have time for Congress to act. To which my response was, look, Congress has passed 15 different pieces of legislation in the 2.5 months since 9/11, including the Patriot Act. So, we can enact major reforms. It's not like Congress is in an emergency situation where they can't meet or something, akin to like Lincoln in the Civil War or something. So I think it should be done that way. Well, anyway, the hearing happened, and like almost all hearings, nothing happened afterwards. And the next week, the House had a hearing, and Larry Tribe, very esteemed law professor at Harvard, testified, and he said something very similar to what I did. And so here I am, I think I'm a 31-year-old law professor. I email Professor Tribe and say, look, I think we both have similar views. Maybe we should write something about it. And so we decide to write a law journal article, because that's what we law professors do. And we stay up day and night for 15 days to publish a Yale Law Journal article with an exhaustive argument about the unconstitutionality. And we wanted to race to get it out because Michael Chertoff had told us, what if we get bin Laden tomorrow and the like, or one of the other high-ranking people, we need to have this system in place now. So we raced it out to publication. Well, nothing happened. Nothing happened for years, like 2 more years. They never even appointed a prosecutor to have a military trial. But 2 years later, they did. And then they appointed a defense attorney. And so I got in touch with the defense attorney, and I said, his name was Colonel William Gunn, remarkable man, one of the best lawyers I'd worked with. And I called him up and I said, it looks like there might be these trials. I think they're unconstitutional. I want you to see I want you to see the argument. Here's my law review article and the like. And he says, Neal, I need to stop you there. Don't say another word. And I said, why? And he said, I have no attorney-client privilege. I said, what are you talking about? You're the chief defense counsel. And he said, yes, I have no attorney-client privilege. Everything you say to me, I have to report to Secretary Rumsfeld. It's like, okay, that's the weirdest defense counsel arrangement I ever heard. But of course, this is what happens when you have the president getting to write all of the rules for the military trial. It was just an indicia of what this whole thing was really about. So I say, okay, so we hang up the phone. And then a couple of weeks later, he says, I have a workaround. I'm able to hire 2 junior lawyers who do have attorney-client privilege. These are 2 Navy JAG attorneys. And I started working with them. Every week we would meet, and we started to create the architecture of a test case that would challenge the Guantanamo military trial system. And one of the things I had really talked to them about, I said, look, this is going to go to the Supreme Court. We need to figure out the ideal plaintiff, someone with good facts, because one of the things the Supreme Court at that point in particular really cared about was the facts of individual cases. That's not always true. The Supreme Court, like now, I think doesn't. They understand that whatever ruling they make is going to bind the nation as a whole in all sorts of cases to come. But at the time, Justice O'Connor was on the court, and she was very much that swing vote on the court. And she was famous for really drilling down into the facts. So I said, look, to get Justice O'Connor's vote, we need someone who doesn't have blood on their hands. Obviously you're picking from people at Guantanamo to be the test case. It's not like picking from our forum. And, so everyone's going to have some sort of accusation against them. But within the range of that, I said, it'd be better to find someone who wasn't directly violent in some way, shape, or form, or alleged to be. So one of the JAG attorneys, Lieutenant Commander Charlie Swift, calls me up one day and he says, I think I got the guy. You want the good news or the bad news? I said, the good news. He says, okay, I got a guy. He does not have blood on his hands. He's not alleged to have blood on his hands. I said, okay, what's the bad news? He said, well, he drove for a bad guy. I said, who's the bad guy? He said, Osama bin Laden. So the question was, in my mind, do we take this case and make it the test case in which obviously working with a person of extreme evil, Osama bin Laden, but as a driver. And so the question was, is that enough to almost taint him so much by association that our legal arguments would get clouded by this? And ultimately, I only had a few minutes to decide because if, basically they gave us I think just a very short amount of time, just in a matter of minutes or hours to take the case or not. I said to Charlie, I think this is good enough. I think this is good because a driver is very different from being a bad person. Being the driver to a bad person is different from being the bad person. And I said, let's try. So he goes down to Gitmo within a few hours and gets Hamdan's authorization for us to file a lawsuit. I'm a law professor, I'm 31. I got no law firm or any sort of help. And Charlie, I've got the two JAG attorneys, but they also don't have any other form of help. But we just decided this is what we're going to do. We tried to approach some law firms for help. Everyone turned us down. Nobody after 9/11 really wanted to work for folks at Guantanamo. But ultimately, I had a former student at Perkins Coie, a Seattle law firm, or a national law firm, but based in Seattle. And they agreed to help. So we started to write this complaint. And then we argued it. And I argued it in the trial court in DC and won. And I remember right after we won, I went to Guantanamo. I'd been trying to go to Guantanamo for 10 months to meet my client. His name was Salim Hamdan. And the government kept saying, you don't have a reason to go. And I said, well, I'm his lawyer. I should be able to meet him. And they said, no. They said, you don't have security clearances. I said, I have more security clearances than you've ever heard of. Look at me. I used to, be national security advisor. I had everything. And they said, okay, yeah, you do. And they're still active. And I said, so what's the problem? They said, well, you don't have need to know. There's two levels that's in security clearance world. There's, do you have the requisite level of clearance? And then do you have a need to know the specific information? Because you want to compartment it so it doesn't kind of spread willy-nilly. When they said, you have no need to meet your client, you're making legal arguments. And those legal arguments are, just abstract and you don't need to meet Hamdan. And at first, I'm so deferential to the government. I was like, okay, that makes some sense. And then I thought to myself, no, this is not me acting as a law professor. This is not me writing a Yale Law Journal article. This is me acting as a lawyer for a client. It's his case. It's not my case. And I should be able to explain the case to him and get his views and so on. So I called back the Pentagon and I said, could I have that in writing that I don't have a need to know? And then all of a sudden they let me go to Guantanamo because they knew that I'd give that to the New York Times and they'd look really silly for not letting a lawyer meet his client. So I get down to Guantanamo. This is a long story, and we're now going to start to move into the legal aspect of this in a second. But this is a little bit, I think this is a bridge in the last part of the story, but it's the part that's legal. So I get there, and it's a 30-hour trip they make me take to Guantanamo. It's normally like a 3.5-hour plane, but they made it really hard for me. And I finally get to see him. And he looks at me and he says, I want to talk to you alone, just with the translator. And so I said, okay, fine. And I think he's going to yell at me because he's been in solitary confinement for 10 months, has not seen another human face. And our CIA manuals say you do that to someone for 3 days and it causes the risk of permanent psychosis. So 10 months. So I think he's going to yell at me, and by all means, he has the right to. And he looks at me and he smiles and he says, look, I just have one question for you. Why are you doing this? Why are you representing me? I heard the last client you had was Al Gore in the 2000 election. I was one of the lawyers on that. And he says, why are you going from that to this? And I remember being so shocked by the question. I didn't have an answer. I'd argued his case. I knew all the legal intricacies, but I hadn't taken that step back to say, why am I doing this? And so a half minute, 45 seconds pass and I don't answer. And I remember thinking in my head, Neal, this is why you should stay a law professor, because, client asks you a simple question, you can't answer it. You're not going to be any good in court. This isn't your thing. And then I thought 5 seconds later, well, maybe it's okay, because when you ask Justice Ginsburg a question, she will pause for as long as a minute before answering it. So maybe I'm okay. And then I thought to myself, well, that doesn't matter. He doesn't know who the heck Justice Ginsburg is. But what I said to him after about a minute of reflection was, look, my parents came here from another country, from India, and they came to the United States not because of the quality of its sports teams or the quality of its soil. They came because of a simple thing, which is they could come to this country and be treated fairly, and their children would be treated fairly. And I said, that had always been my experience. I've been so privileged to go to these schools and work in the highest reaches of government and the like. How amazing an opportunity, a set of opportunities I had. And I said to him, the first time in my life that vision of America, my parents' vision, was truly violated was when President Bush wrote that order. Because when he wrote that order, he said, if you were one of the 7 billion people who's not a US citizen in the world, or whatever that number is, and you're accused of a crime, you get sent to Guantanamo. You get the beat up Chevy version of justice. If you're one of the 300 million American citizens, you get the Cadillac version of justice. You get the American civil trial. You could be accused of the same crime or even a worse crime, and you get the civilian trial. But if you aren't, if you're a green card holder, as my parents were, you get the beat up Chevy, you get sent to Guantanamo. And I said, that we've never done before, literally in America, ever. We've had military trials before, but we always applied them equally to citizens and aliens alike. And I didn't say this to him, but I say it to you as we start to think about the role of the law in all this. The Equal Protection Clause of our Constitution guarantees equal protection to all persons. It doesn't guarantee it to only citizens. And that's very intentional, because Representative Bingham, who wrote the 14th Amendment in the 1860s, said, I need to overrule the worst line in the worst Supreme Court case in American history, the line in Dred Scott versus Sanford, in which it says only citizens have constitutional rights. Representative Bingham said that's what we fought this war about. And so the word's intentionally persons. And here we have a person who's being fundamentally denied equal protection of the laws. He gets one set of laws and rules because he's not a citizen. And so, I felt like there were very, very serious legal problems. And so won the case in the trial court, argued it in the DC circuit, our nation's second highest court, and lost on July 15th, 2005. July 12th, 2005. The reason why those dates are significant is because I argued the case before a guy named John Roberts. And on July 15th, 3 days later, after the ruling, he was nominated Associate Justice to the Supreme Court to replace Justice O'Connor. And then 2 weeks after that was named the Chief Justice nominee, because Chief Justice Rehnquists had unfortunately passed away in the interim. So I was now about to ask the Supreme Court in a certiorari petition that says, hear my case. I was going to ask them to overrule their new Chief Justice on the most important decision he had rendered on the lower court in his lifetime. Not an easy thing to do. The court generally likes to stay away from military issues. They don't think they have the expertise and the like. But nonetheless, mounted a very concerted effort, and the Supreme Court agreed to hear the case. On November 7th, 2005. 4 days later, on November 11th, 2005, the Senate passes a bill because Lindsey Graham and John Kyle come to the floor of the Senate and say, emergency, the terrorists are about to get their case heard by the Supreme Court. We need to stop the Supreme Court from hearing the case. So they pass a bill to remove the case from the docket of the Supreme Court. The last time that happened was in 1868 in Ex parte McCardle. Obviously, one of the gravest interferences with the functioning of the court you can imagine. And I then went from being a lawyer to being like a lobbyist. Of course, I don't have like bridges or money to offer the way that the president does on his side, but I was able to work with the House to basically insert 2 commas in the bill and split apart the provision to make it look like they wanted to grandfather our case, but just say for cases going forward that the Supreme Court couldn't hear them. Ultimately, that was successful. The Supreme Court did agree to hear the case, and they did not think that this legislation in Congress was clear enough to remove the case from the docket of the Supreme Court. Now, this is my first Supreme Court argument. I'm incredibly freaked out. In fact, right after the Supreme Court agreed to hear the case in November, I called up a couple of lawyers who were conservative because I didn't want politics to matter in this. I didn't think it was a political issue. So I called up Ken Starr and I called up Miguel Estrada, another very prominent conservative lawyer. And both of them wanted to do the case, but for various reasons couldn't with their law firms and the like. And certainly like lots of people were calling me saying, hey, I'll argue the case for you for free and this and that. But ultimately, I didn't feel like any of them knew the case well enough. I'd spent 4 years doing it, researching it and so on. And so I took a legal pad out and I wrote down the names of every lawyer who scared me the most in the country. And I called them all up and I said, will you moot me? Well, can I practice my argument in front of you? And I did. And so I did this 15 times. I practiced the case and then, felt ready to argue it. Now, oral argument to the court now is very different than it's been historically. So now it's a half hour per side. Back in the old days, like Daniel Webster and the like, the arguments were like 6 or 9 days long. Now it's a half hour. So it's like, I had a Hindu wedding. Normally those are like 3 days long, but I married someone who's Jewish and she didn't want it to go on for 3 days. She gave me 30 minutes. So basically same thing, compress the Hindu marriage into 30 minutes, compress the 6-day oral argument, 30 minutes. I get about 50 questions in a half hour oral argument. So that means that the rapid fire questions, there's a premium placed on how quickly you can answer something, how efficiently, how you can get to the point, and then invite another question that you want. And it can be very challenging. I mean, Justice Scalia in particular loved to give me a hard time, and I'd love to answer it too. It was a lovely thing to have the privilege of arguing before someone who was that on it at argument and that sharp. But sometimes trying to trip you up. And so you've got to be really, present and aware. The court just physically is different than other courts. The podium is just about 9-10 feet away from the Chief Justice. So you're really close to one another. And if you're sweating, as I'm sure I was in that first argument, he sees it. And the other justices, the other 8, are spread out about 30 feet on each side. So it's a big, long bench. You can't see everyone at once, but you're always trying to look to see who's concerned, who might appear to be buying your argument, and the like. And one of the things I learned in the mooting process was that I was too used to like giving a speech the way I'm talking to you now, and not enough. I wasn't conversational enough. And the best oral arguments at the Supreme Court are conversational. It's much more, and this is the image I use now, thinking about being around a dinner table and us having a conversation as opposed to an argument where I believe X or Y. So anyway, I'm arguing the case against the Solicitor General. It's his 35th argument. It's my first. And, but I have a very simple kind of point, which is, that you can't just have the president, by the stroke of his pen, do whatever he wants. As Justice O'Connor had put it a couple of years before, a state of war is not a blank check for the presidency. And indeed, just to remember that in my mind, I literally had a blank check in front of me at the podium. That's what I brought up to the podium, just so that I would remind myself to say that, yes, the court wants to defer to the political branches and the president in times of war, but not so much that the president gets a blank check. And so my goal was to explain why this system at Guantanamo was such a deviation from norms. And so the argument went very well. And ultimately, a few months later, we were sitting in the courtroom and learned that we had won, that the Guantanamo tribunals were coming down in a 5-3 decision by the Supreme Court. And it was a really long opinion. It was 184 pages. The justices summarized it from the bench pretty quickly. And I then went outside to 500 cameras on the Supreme Court steps. President Bush had already given a speech and answered some questions about it while we were still in the courtroom. But I came out and everyone's like, what does the decision say? The decision was 184 pages. I hadn't read it. Nobody had read it. But here's what I said. I'd written down on the Metro into the court that morning some notes if we had hopefully won. And the notes basically, and this is what I said, was, look, here's what you have. You happened today. You had a guy who's the lowest of the low, accused of being one of the world's most evil men, and accused certainly of conspiring with one of the world's most evil men. And he brings a case not just against anyone, but the nation, the world's most powerful man, the president of the United States. And he brings his case not just in some rinky-dink traffic court, he brings it in the highest court of the land, the Supreme Court of the United States. And he wins. That, I said, is something remarkable about this country. In many other countries, this driver would have been shot just for bringing his case. And more to the point for me, his lawyer would have been. But that's what makes America, to use a loaded phrase now, great, what makes America special. That we are that exceptional, that we recognize our leaders can make mistakes, and that it doesn't matter who you are, you can challenge it and you can win. And it reminded me of what Chief Justice Roberts said at his confirmation hearings back in 2005. He said that the great thing about the Supreme Court is that on the one side of the courtroom, you can have the big corporation with all their fancy lawyers and the legal books piled up high. And on the other side, you can have some guy doesn't have all the fancy lawyers or books, but if he's got a good argument, he can win. Not always, but he can. That's what makes our court system our court system. And that's what happened in this Guantanamo case when we won, which didn't just change entirely the nature of the Guantanamo tribunals. It also said that the Geneva Conventions applied to the war on terror, which meant literally that day, ghost prisons ended, waterboarding ended, a whole bunch of stuff, not just at Guantanamo, but across the globe. That to me is our court system at its best. Not like interfering willy-nilly in presidential, decisions about national security, but fundamental matters of justice and the like. Now, I wish I could say that's always how the court works, but it's not. And the other story I want to tell you before I take your questions is about the Muslim Ban litigation, which I also led. That started right after Donald Trump won. 6 days later, you might remember that there were those scenes at the airports because the president issued a surprise executive order that basically was, a restriction on Muslim immigration to the United States. It isolated 7 countries, all with very high Muslim populations, between 90.9% and 99.9%, and said basically that it was basically a ban almost on immigration from those countries. And here, I don't mean to be political. And indeed, just like Guantanamo, there were lots of conservatives who stood with us in the Muslim ban litigation. I do think that Donald Trump, stoked these fires. He started by on December 7th, 2015, in a campaign speech saying, I, Donald Trump, am calling for a complete and total shutdown of all Muslim immigration to the United States. And he later gave speeches which said things like, I think, quote, Islam hates us and the like. So he then issues this order, and we and others sued, and immediately that first order was struck down. He then said, I'm going to create a second one, a new and improved one. We were ready. I was working with the state of Hawaii on it, and we filed a lawsuit, got that one struck down. He then said, I'm going to go to the Supreme Court and defend the Muslim ban. So we said, fine, bring it on. And 2 weeks before the oral argument in the Supreme Court, he pulls that one back and he changes it again. And this time it had some changes. So it added some countries. It added North Korea, because we have a big immigration problem with North Korea. It's really a swamp at our borders. And he added about 100 people from Venezuela, whom I think worked in the travel office or something like that. That allowed him to say, well, this ban is not a Muslim ban because we have North Korea and we also have some people from Venezuela. Now, I thought that we basically had a good answer to all of this. Now, what the Trump lawyer said was, there's nothing on the face of the order that says it's a Muslim ban. The word Islam is never used or anything like that. It just happens to isolate countries that are, overwhelmingly Muslim, plus Venezuela and North Korea. And what I said is, you can't just look to the face of the document. You've got to understand what the history of it is. So I said, for example, imagine the president said on Monday, I hate Jews, and on Tuesday bans immigration from Israel. I don't think it allows him on Wednesday to say, well, it doesn't say Jews in the Tuesday executive order, so it's not motivated by any sort of anti-Semitic beliefs. I think you have to look to the history of the document. And at the oral argument, Elena Kagan totally got that. But unfortunately, the Supreme Court, in a 5-4 opinion written by the Chief Justice, ruled against us and said, basically, the face of the order didn't discriminate against Muslims. And I was devastated. I was completely, I thought, just like for Guantanamo, even though everyone said we were going to lose, I thought this was a slam dunk, easy win, just given our nation's values and what this, Muslim ban said about it. I mean, the idea that we were going to, this country that was founded on religious tolerance was going to have a litmus test like that. I just couldn't believe it. The one thing I was so upset, but there was one thing in the opinion that gave me a little bit of hope, which was the Supreme Court, in the course of upholding the Muslim ban, decided to overrule one of the worst cases that they had ever rendered, which was a case called Korematsu versus United States, and the accompanying cases, Hirabayashi versus United States and Ex parte Endo. These were cases in which the Supreme Court basically let stand the internment of over 100,000 Japanese Americans. And when I was in the Solicitor General's office back in 2011, I remembered that one of my college professors had mentioned in a lecture that he thought that the Justice Department and the Solicitor General's office had lied to the Supreme Court about the need for the internment of Japanese Americans. So just something like that, just kind of random comment he said once. But I thought to myself, well, now I'm running the office, let's look into it. So I looked into it, and it was 100% right. And indeed, a historian named Peter Irons had uncovered a lot of the documents and the like. And then I went and got them all. And ultimately, I wrote what was called a confession of error about how the Solicitor General in World War II basically lied to the Supreme Court and said there was a military need for the internment and for all these restrictions on Japanese Americans that just turned out not to be true at all. Their rationales were totally made up, and there was very strong evidence from the Office of Naval Intelligence, which had the lead on all these questions, that you didn't need to have any of these restrictions and that they were motivated by prejudice. And indeed, J. Edgar Hoover, who's like no fan of civil liberties, agreed with the idea that with the Office of Naval Intelligence and the idea that these restrictions were unnecessary and prejudicial. So I brought all of that to light back in 2011. And as I say, Peter Irons had already done a good amount of that as an academic earlier. But it allowed, I think, a bigger conversation about the obligations lawyers have, particularly Justice Department lawyers, to the Supreme Court, to the process, because you get access to all sorts of very sensitive information and you make decisions on that basis. The court doesn't get access to all that stuff. And because of that, you have to be so up and straightforward and honest about what the intel says. That's not what happened in World War II. And when that doesn't happen, when you have executive branch officials that play fast and loose, it makes it much harder for the court to do their job. And then they have to scrutinize the executive even more because they can't trust it. So I think, I'll leave you with that. It's and then take your questions. I mean, I think, the role of the court is an important one, even in wartime or in national security situations. I'm not someone who thinks that they should just, willy-nilly intervene, like I was against the drone strikes litigation and things like that. But on matters of fundamental justice, there is an appropriate role for the courts to play, provided that the claims are made on a limited basis. So with that, I'm not sure exactly how we'll do the questions, but I'm here for you.
If you have a question, you can either use the raise your hand emoji through Zoom or unmute. I see David, you have a question. You can go first.
Thank you. And thank you to our guest. It was wonderful to hear what he had to say. You mentioned the term test cases, and I have thoughts in two areas that I think are related. And that is, I believe historically, a lot of the cases that get to the Supreme Court, or at least a fair number, are designed to get to the Supreme Court in certain ways. I think perhaps Brown versus Board of Education, certainly Citizens United, and the way it was re-argued, smack of that. And the area I'm thinking of right now is the election laws. I saw something last night or this morning about how the Heritage Foundation has been going and trying to direct Republican legislatures on how to fashion laws that will stand up to scrutiny and things like that. And we know that now Chief Justice Roberts, when he worked in the Justice Department or in government, was one of those people that really didn't have a problem with election restrictions, and he wrote the opinion that gutted the Voting Rights Act. So I guess my question to you is, what do you see in terms of all these attempts to undercut democracy right now? I mean, you have the traditional roles were gerrymandering and voter suppression, but what we have now is actually the Stalin-esque thing is we're rigging who counts the votes. Where do you think that's going? And do you think at some point even Justice Roberts will look at the legacy of the court and perhaps see things a little bit differently?
It's such a lovely set of questions. Thank you for it. Just before getting into voting and democracy itself, just this notion of test cases. Certainly, there are a small set of big, important cases in which you do basically have a test case strategy. And Thurgood Marshall totally pioneered this in the 1940s with the school desegregation, ultimately leading to Brown versus Board of Education. And very much he was my model when I was thinking about Guantanamo. How do we build that slow, steady thing. How do we pick the plaintiff and so on? But that is really the exception at the Supreme Court. So of the 60 or so cases the Supreme Court hears every year, 50 you probably never heard of. Like they're smaller, more technical cases. They're really important. Like next month, I'll be arguing a case to protect veterans and their Social Security benefits. Obviously really important to them, but you're not probably going to read about it in the newspaper, and it wasn't created as some sort of test case or something like that. So I just want to bracket like the big kind of usual functioning of the court and then how it functions in the big cases, the ones that you're asking about. And if any of you are interested, I'm going to be teaching a 4-week thing on this called, it's on a platform called Chapter in November, just a real kind of much more intricate, detailed nuts and bolts on how the Supreme Court works and how it works in big cases like Roe versus Wade and the like. So that's on my Twitter if you want. Okay, now on voting and democracy. I very much agree with the spirit of your question. Indeed, I had the privilege of arguing the Voting Rights Act case and the constitutionality of it, of Section 5, back right after President Obama had won the election. And I won it 8-1 in the Supreme Court. And so Section 5 of the Voting Rights Act, passed in 1965, was the provision that said that if you're one of a state, if you're a state or locality that has a history of discrimination in voting, you're not allowed to just change your voting rules by yourselves. You've got to get pre-clearance from either a court or from the Justice Department. Because what was happening is you had these southern jurisdictions that would like change the polling hours, voting hours, like the day before the election, and basically only tell the white people about it. And so, or they would make it so you had to vote between 9 to 5, which are, which is going to disproportionately impact African Americans or the like. There's a whole bunch of shenanigans, and there were so many of them. What Congress said in Section 5 was, we can't even anticipate all the creative ways you're going to disenfranchise people. So whatever change you make, you got to get pre-clearance. So I argued that, as I say, in 2010. The law initially started in 1965, but it had to be reauthorized every few years. And this one was reauthorized in 2006. And here's how kind of what a consensus we had about voting back then. The vote in the House of Representatives to reauthorize Section 5, 421-3. The vote in the Senate, 98-0 in favor of this. Indeed, at the oral argument, I argued the case for the government, and then I had a dear friend of mine, who argued the case for the NAACP Legal Defense Fund. And Justice Scalia asked him, I wish he asked me this question. He said, this law passed 98-0. It must be symbolic. Nothing passes 98-0 in the Senate. And I had the answer at the tip of my tongue, but I wasn't at the podium. I'd already finished speaking. And the answer was, Justice Scalia, your confirmation vote, 98-0. But I didn't get to say it. But that's where we were. And the Chief Justice wrote an opinion to uphold the Voting Rights Act 8-1, but said there has to be data, on the degree of voting discrimination and the like. Well, 4 years later, the case came back. And in Shelby County, that's the name of it, the Chief Justice flipped the vote, and 5-4, saying there isn't evidence of discrimination anymore. And the Section 5 of the Voting Rights Act violated what he called the equal footing doctrine, the idea that Congress can't treat states differently. That's a very interesting proposition for someone, for people who are so-called strict constructionists who believe the text of the Constitution controls, because there's no such thing as the equal footing doctrine in the Constitution. You could look at up, down, sideways. It doesn't exist. To the extent it does exist as a matter of judicial precedent, it just means when you're admitting states into the Union for the first time, you can't give some special benefits and others special disadvantages. It's never been applied to anything else, but that's what the Chief Justice used. Justice Ginsburg wrote the dissent, the lead dissent, probably her best opinion ever, but one of the best opinions of any jurist of the Supreme Court ever. she lambasted this. And now the question is, where do we go from here? I'm very concerned that we are losing this fundamental idea that we are in a democracy where a majority controls. I think there are so many attempts now to try and disenfranchise, both through voting restrictions, because there is no Section 5, so they play all sorts of games, but even more significantly, propositions like the one that you're adverting to, in which they're saying if a state legislature disagrees with the vote of the citizens, if they think it's fraudulent, they can appoint the presidential electors themselves. That is what's being introduced in places now, like Arizona. So imagine if that had been the rule in this last election. It would have permitted these state legislatures to just say, look, I think there was fraud. We're going to pick Trump. And they're fundamentally in tension with what our democracy is about. I do think that I am very optimistic that the Supreme Court will strike such restrictions down. I'm less optimistic that they will police the channels of voting more generally. And so I do think it's up to Congress to have a new Section 5. And if the Congress wants, I mean, if the courts want to say there's an equal footing doctrine, so you can't just isolate, prior states that discriminated, which tend to be in the South. If you want to apply it to all 50 states, fine, equal footing, apply it to all 50 states. That's what the John Lewis Voting Rights Act does. It applies this pre-clearance regime and says, if you're in any state, you can't change the voting rules without going to the Justice Department or getting court approval. That to me is absolutely fine, and a way to deal with this problem. But so far, there hasn't been the votes to get that thing passed. But I think it should. I think, I know a lot of people have views about the filibuster, that's an important tool and so on to restrain Senate adventurism. But when you're dealing with something as fundamental as voting, I don't think that we can let a minority of people in the Senate, at least controlled by population, decide such a thing. So I'm in favor of abandoning the filibuster for voting and indeed for abortion too. And we can talk about that in a little bit.
Okay, Jack, you have a question, and then Sandra will get to you.
Yes, you often hear it said in the mainstream press that there's a 6-3 conservative majority on the Supreme Court, which I think is greatly oversimplified. I'd love to get your opinion on what I think is the real alignment on the court. I think you have the conservative constitutionalist Thomas wing of the court, which would be Thomas, Alito, Kavanaugh, and Barrett. I think you have the liberal interventionist wing, the Breyer wing, with Sotomayor and Kagan. And then I think you have the two swing justices, John Roberts and Neil Gorsuch, more so Justice Roberts being a swing. The advantage that gives the Thomas wing is that they only need to get one of the two swing justices to form a 5-4 majority, whereas the Breyer wing needs to get both of the swing justices. What do you think of that?
Well, I mean, I think I'm not someone who can probably, I don't agree with the labels all the time. And it really depends more on the issues. Sometimes Gorsuch is the swing vote, as you say, on cases like Native American cases and some criminal cases. Sometimes that swing vote could be Kavanaugh on kind of separation of powers cases and the like. I do agree that there are some distinct methodologies that we see at the court. Justices Thomas and Alito tend to see things pretty similarly and tend to be okay reversing precedent if it doesn't comport with the original understanding of the Constitution. And so they basically are saying, we think the founders trump our prior colleagues' decisions on the court. Justice Gorsuch also, I think, there. the Chief Justice and Justice Kavanaugh tend to be a bit more pragmatic and less, kind of doctrinaire about it. I wouldn't say they're as pragmatic as someone like Breyer, who I think is always trying to say, yes, you have a text in the Constitution, but it's got to be a functioning, working document. You can't just kind of import the founder's view from 200 years ago into today rigidly. You've got to adapt it. It's a constitution that's supple enough to adapt. I think Breyer's view is probably, the intellectual genesis of it is a case called McCulloch versus Maryland, written by Chief Justice Marshall in 1819. In my view, it's the most important case in all of constitutional law. So I'll spend an entire fourth of the chapter class in November on that case. That's the case that upheld the Bank of the United States. That's the case that is dramatized in Cabinet Battle #1 in Hamilton, the musical. The whole idea that Chief Justice Marshall says is that we are under a constitutional system that's very different than a system of rules and statutes, which are very specific and calibrated and have all sorts of exceptions in that. The Chief Justice said, it is a constitution we are expounding. And by that, he says it doesn't have the prolixity of a legal code. It only marks the great outlines of our government and allows for flexible governance and suppleness. When I was putting together the defense of the Affordable Care Act for President Obama, this case was the center of our defense. Yes, there's no prior case that upheld the idea that the government can force you to buy a product like health insurance. But in order to make government work, in order to make the citizenry work, we said that was implicit in the Constitution and its great outlines, relying on McCulloch versus Maryland. So I think you can really see that shift. Of course, there, Chief Justice Roberts cast a deciding vote to uphold the Affordable Care Act. Again, I think he's far more pragmatic and less doctrinaire than some of those jurists that we were talking about earlier, like Alito and Thomas, who believe their job is to basically read the Constitution, say what it means. The consequences can be whatever the consequences can be.
Thank you.
Hey, Sandra, go ahead and unmute.
Allison,
Hold on, Maury, 1 second. Sandra, go ahead, unmute.
Yeah,
Maury-
I'm unmuted.
Oh, there you are, Sandra.
Be
Go ahead.
unmuted, yeah. I want to just turn to January 6th and wonder, is this the new norm? Is it going to happen again? I guess it will. What can we do?
Well, I hope it doesn't. We all hope it doesn't. It's not clear to me it's the new norm. I do think that we have some leaders like former President Trump who want to make it the new norm, who are happy to make our government look like, some third world country's government, and our society. I can't imagine that. I can't, and I have enough faith in the American people that, will come to our senses. But I do think it's really a deep concern. And so what that means is I'm really happy to see law enforcement and the intelligence community really taking these threats seriously. Fences just went up in the Capitol yesterday. That's not something I'm happy about. As I said on TV last night, Donald Trump at least, got a wall built. So finally, I think what we have to do, and this is why things like this are so important, is I think we do have to return a little bit to, what is this national experiment all about? What is the Declaration about? What's the Constitution about in its heart? It's about the fact that we can live and disagree profoundly with one another and yet not take up armed insurrections. That's the whole idea behind it. That's what the glorious First Amendment's all about. And so somehow I think we need to recapture that. So one of the things I'm doing is a children's show about the Constitution, like a TV show with cartoons and stuff, to really try and get at that idea that, what is this spirit of democratic deliberation about? And I think we have to do it in our own lives. And that means like, really being friends with people who think differently than us. And somehow we have to role model that for everyone. So I don't know, I don't have any wise solutions to this. Some of it is going to be legal. My nonprofit at Georgetown, we lead all the anti-militia litigation in the country. And, we say, look, it's absolutely fine for people to march. We have no problem with that. You can speak all you want in favor of Trump, against Biden, whatever. The election was stolen, but you can't like do it wearing military garb and carrying an AK-47 or whatever. There are laws in many different states that go back to our founding that prohibit the impersonation of militias, of real militias, of law enforcement officials, or National Guard or the like. And so we're using those in the various states to enjoin marches that are more military in nature. So that's one way in which the law can help, but it's modest. And I think fundamentally we need to figure out how we're going to recapture this democratic spirit, particularly in a world in which I think a lot of foreign state actors want to prey on us and prey on our divisions. They're so happy to see all of this, if you're China or Russia. So I think it's a real challenge. And the guy who used to run my nonprofit has just left to go to the White House in January to run the militia response. And he is brilliant, like one of the very, very 2 or 3 best government officials I've ever worked with. So, I mean, it's a sign to me that Biden's taking it really seriously. And this should be, again, non-political. I mean, there's a way to do this, which is not about, one side winning or losing. It's just about trying to prevent violence and cultivate democratic dialogue.
Maury, go ahead, and then Larry and Paula.
Yeah. 4 days ago, your former mentor and now your colleague, Akil Amar, was before this very same forum. And he spoke about his appearance before the Congressional Committee on altering the Supreme Court. And one of his suggestions was that there be relaxed role by justices. Do you have an opinion on that? And do you have a further opinion on should there be any further adjustment on the Supreme Court?
Say that again. What was his proposal?
His proposal was relaxed role after 18 years where they.
Oh, okay. Yeah, 18-year terms. Got it. Okay. So I'm a big fan of 18-year terms. I have been for decades now, just because it's very unseemly, the whole thing about, trying to guess at a justice's health and stuff like that. And I don't really like the idea that it's kind of, some presidents get really lucky in the number of appointments they get and others don't. So I like the idea of an 18-year term, which turns out to be the average of tenure of Supreme Court jurists anyway. Now, I think it can only be on a going forward basis. I haven't thought about it enough, but my gut is you can't take the current justices now and impose 18-year terms. I think Akil might have a view that there's a way to do it, and maybe there is, but I think it's complicated. But in general, I like that idea. I don't think that's going to solve the current problem with the Supreme Court, because the current problem with the Supreme Court is that the Republicans, as a party, have monkeyed around with it, and not filling Justice Scalia's seat when he died in mid-February 2016 with the idea that they claimed it should be up to the next president to decide that. And then when Justice Ginsburg passes away with like a month before the election, they race to get Justice Barrett through. I mean, you can have one or the other of those things. You can't have both. That's just unprincipled. And that is playing ducks and drakes with the federal judiciary. And there has to be some sort of response to that, because, as just a matter of basic kind of governance, there has been a deep violation of our norms. And we will start to see the consequences of that. I mean, we did last week with the Texas decision on abortion and SB 8, and there will be new things to come. So this is, this is not low stakes. This isn't traffic court. This is some of the most high stakes stuff imaginable, and one in which they played games. And so something's going to have to be done, and an 18-year term isn't going to solve it. Thank you.
Okay, Larry, go ahead.
Okay, thank you. Neal, first of all, thank you so much. It was a very interesting and a very informative program today.
Thank you.
My question is fairly direct. Based on your experience and your insight, and you certainly have quite a bit, where do you see the future of the Supreme Court, and what do you feel are some of the more important issues that will have the court's attention over the next number of years?
Well, I mean, to take something that is probably not as much on people's radar, but I think is very important, is criminal justice reform. I mean, I think that there is a growing consensus in this country that we have gone off the rails in the number of people we incarcerate and who gets incarcerated, who gets quality defense attorneys, and the like, mandatory minimums, all of these different things. And this is an area where I think the Supreme Court can come together on the left and the right. This is something Chief Justice Roberts talks a lot about, something Justice Gorsuch talks about and writes about. So I think that's an area in which I'm hopeful and optimistic. I do think that probably for the next several years, the thing that's going to dominate the court, at least in terms of the eyes of the public, is Roe versus Wade. And that's maybe one of a couple of decisions that Americans know by name, along with Brown versus Board of Education. The idea that this Supreme Court and the way that these justices got, or some of them got to their positions, voting that way, I think would be unimaginably corrosive to the institution of the court. And so, I think all of us are really worried, who practice at the court are really worried about that, because at its best, the court does something magnificent, like Brown, like the Gitmo case I told you about, like striking down President Trump's games with the census and citizenship question. These are really important roles for the United States Supreme Court. It's going to be hard to perform those roles if they don't have the trust of the public. And so I think Roe will dominate things. This year, probably the other big case so far is the New York gun case, involving whether or not New York can regulate the private possession of firearms outside of the home. And whether you can openly carry those, or excuse me, the concealed carry those firearms. That's the New York case, in New York. But the ruling will obviously apply to the whole country. So that's one. I think affirmative action will come back to the court at some point. That's another, I think, hot button issue. And then this whole question about religious exemptions is, I think, a really big deal. I had a case last year where I represented Philadelphia. Philadelphia gives grants, or basically hires contractors to screen foster care parents, people who want to be foster care parents. They use 30 different contractors. 2 of them was discovered by a newspaper discriminate against LGBT families or foster parents. And they said, we're not going to screen you. It's against our religion. So the city terminated those contracts with those 2. Those folks then sued, saying they were constitutionally entitled to the contracts. And the Supreme Court agreed that they were constitutionally entitled to those contracts. And they've also restricted, they've undermined the ability of governments to react to COVID and to say, you can't apply masking restrictions or hours restrictions to churches or religious places of worship and the like. So I think that whole set of questions is going to be very, very deep and interesting as well.
Okay, we'll take one more. Paula?
Yeah, I have a couple of questions. First of all, how much power is Judge Garland going to have pertaining to Texas and about the abortion issue? And should we pack the court in order to make it more even? And also, what is your prediction about Roe versus Wade?
Yeah, I'm not going to predict Roe now. I've definitely been saying for a year and a half that it's tenuous, and because of that, that Congress needs to act and pass a statute to codify Roe versus Wade. Packing the court now would require, a majority vote in the House and Senate, but first to expand the size of the Supreme Court, and then to confirm individual nominees. So, there are, at least right now, Senators Manchin and Sinema are saying they're adhering to the filibuster and saying they're not going to do that. So you're going to have to jump over that before you get to any sort of quote unquote court packing solution. If you can't have a court packing solution, then it becomes, like, then what happens? Like, do we just let this thing fester? I think it's a really, really hard set of questions. It'll be made even harder, and this gets to your very first question, because the US Justice Department has only limited abilities to actually do stuff on its own. What they do is really file court cases. And so they can file, as they have, a case to challenge the Texas abortion law. But who's going to decide that? It's not local judges in Texas. It is ultimately the United States Supreme Court. And so right now, there's a very limited set of tools to react to this, power grab by one political party at the Supreme Court. And, I don't know where this ends. And I'm very worried about it.
Thank you.
Okay. Well, it's 1:28, and at this time, I would like, in a way of thanking you and saying goodbye to you today, I would like you to promise to come back to us.
Of course. It was lovely. Great questions.
It's
Really great.
it's been very relieving, when we it's such a fractious time in our history, and it's we need the confidence to work hard to make us the America that we want it to be, and you're helping us a lot.
Well, thank you so
Thank
much.
you.
Thank you.
Bye all.